Today I wanted to talk to you about who you should name as an agent in your power of attorney or health care proxy. The choice of your agent or agents is probably one of the most important decisions you'll be making when planning your estate. And it applies not only to financial and medical powers of attorney, but also to who you name as an executor of your estate or a trustee of your trust. First of all, let's get our terminology straight. A power of attorney is a legal document that gives to someone you trust, other than you, authority to act on your behalf in legal and financial matters. A healthcare proxy, also known as a medical power of attorney, is a document where you name someone to make healthcare related decisions for you if you cannot make those decisions yourself. It is different from a living will because a living will is a statement of your wishes regarding your medical treatment, and a living will is effective regardless of whether your healthcare agent is present or not. A living will doesn't give any authority to anyone but tells your healthcare professionals what your wishes are. Now, how do you decide who to name? I always stress to my clients that whoever they choose, they have to make sure that the arrangement is workable. I'll give you an example. A client names her son as an agent, we also call him the attorney in fact, in her power of attorney, and a daughter in her healthcare proxy. For some reason, it's always a daughter who gets to make all medical decisions. Now, once mom is in the hospital, the brother and sister are not on good terms. Well, at least they're speaking to each other, but the son is out of state and the daughter is the one who was taking care of their mother, and they have very different ideas about mom's care. The daughter is considering assisted living, and the brother thinks that she should stay at home, and being out of state, he is obviously not the one who will be providing care. Sounds like a real life situation, but sometimes healthcare decisions also require financial support. The daughter finds a beautiful facility for mom, but the son refuses to write a check. So who is in charge now? The son can effectively block any decision of the healthcare agent that requires payment. Some people feel that if they have more than one child, when they choose one over another, it hurts the child's feelings and somehow shows preferential treatment. And then they base their decision on trying to keep everyone happy, not realizing the practical implications of their decision. At the same time, when the time comes to use the documents, often we see that when one of the kids is placed in the position of absolute power to the exclusion of others, which often creates a rift in the family. So you're probably asking, how can I avoid this? Well, you avoid this by planning. When we design plans with our clients, we spend considerable amount of time discussing their family and who would be the best fit to act as an agent in a financial power of attorney, medical power of attorney, or as a trustee of their trust, or an executor in a will. Don't let it to be an emotional choice. It's nothing but a practical consideration. Just because your son is a financial planner, it doesn't necessarily make him a good fit for your power of attorney, especially if he lives in the West Coast. And just because your daughter is a nurse, it doesn't make her the best choice for a healthcare proxy. You need to consider such things as proximity to you, available time, relations with other family members, decision-making ability under different, sometimes dire circumstances. You can name different people to be your financial and medical power of attorney, and we often encourage our clients to do so. But you need to make sure that they can work together. You can appoint more than one person. You can name 2 or more co-agents or co-executors or co-trustees, depending on your plan, and give them power to make decisions independently or require that they always act jointly. You can create your rules for when one of the agents objects to a decision made by the other. You can name alternates or successor agents, executors, and trustees. You can also name an independent party, for example, another family member or a close friend to provide oversight and act as a referee. There are many options when you plan. Every family is different, and you can't apply the same formula to every plan. We design your plan based on your individual circumstances, and our goal for you is for your plan to work. You can come speak with us, and I'll be happy to review your existing plan and documents and see if it's sufficient or if anything is missing. I cannot promise that we will be able to take your case, and if we don't, we will direct you to another professional, but I will give you my honest opinion about your situation, your documents, and what you should do. If you need help with any of these things, call us at 201-380-2000 or visit us online at www.thelawofaging.com.
Novitsky Law Group is a full-service elder law and estate planning law firm. With 4 offices located in Paramus, Morristown, Jersey City, and Red Bank, we serve communities throughout New Jersey and New York. Call us at 201-380-2000 or visit us online at www.thelawofaging.com. Make sure that you subscribe to our newsletter to stay up to date on important developments in estate planning and elder law.